All right, my beautiful friends. We just pressed the Let's Go Live button, which means we've got to wait for the tubes to connect themselves all across the fruited plain of the interwebs on this lovely final week before the election, Monday. And I'm very glad that you're here and with us. We have an amazing stream planned ahead. But first, I hope your weekend was incredible. And you're coming here today feeling restored and rejuvenated and ready to go. We've got a bunch of fun business to attend to today. Some big stuff actually dropped. And so let's hit a preview before we jump into the actual meat and potatoes. Big news out of Nevada, a pretty important state. I think it's up there on the list of the swing states. Maybe not at the top of the list, but it's up there. We got news that now the court has ordered that the ballots that come in after the election is already over, they can be counted. They will be counted. So they'll come in late, no big deal. They'll still just, whatever, perfect. So after election night is over on election day, when it's done, they'll just have to figure out what the margin is. And then they got 3 days, and it's not even, you have to be postmarked. Doesn't even have to be in the mail, even if it's unpostmarked, okay? So it doesn't even have to be in the mail. And you're good. So we'll go through that. Bloomberg's reporting it. I got the opinion out. It's from the Supreme Court of Nevada, which is obviously the highest court over there. So unless the United States Supreme Court does something about this, this is how it's going to be this election. So, just vote whenever you want, Nevada. Whatever. You'll see that is coming up very soon. Then we're going to go over to Florida and see what is going on with Jack Smith and Judge Eileen Cannon. Because Judge Cannon, as we know, dismissed the classified documents case, said that one had to go bye-bye because Jack Smith is not a real boy. No, he's an illegitimate prosecutor who was unlawfully appointed, and so everything that he's touched needs to go bye-bye. And so Jack Smith is, I don't know why he's still around. I don't even know why he's still getting a paycheck or he has an office, okay? His office should be boarded up, and he can go back to Europe. But sorry, guys, our friends in Europe, it's true. But this is where we're at in the 11th Circuit. He's trying to get his case back. He's trying to resurrect it from the dead because Judge Cannon threw it out. And now he is appealing it. And I don't know what money he's using because she said that he was stealing the money. So where does he even have the gall to even file this in the first place? Well, we'll go through it. We'll take a look at what's happening there. Then you may have seen this. There's some fires that are percolating in various locations. We saw that there was a postal service fire in Arizona about a week ago. I think we covered that here, talked about it very briefly. It was just a regular mail Dropbox where you just send in your letter to grandma or to your mother or somebody that you love. And you send a letter in, and there happened to be some mail-in ballots in there. Well, this is different because these were the actual mail-in ballot boxes that you're supposed to drop stuff off at specifically for that. And your boy, as you can see, I went and voted today or dropped my ballots off today. I got the mail-in ballots and I went and dropped them off. And I posted a video about that over on our locals. And ours was inside a building. So this is your boy walking around today. And it was actually inside a building. So a little different than what we saw. It was inside, no, not that building. Well, that one right there. It was inside that building and not like those other drop boxes. But what I've learned is that now we can take a look at the Arizona video feeds, and we actually do have some ballots, ballot drop boxes that are outside, and so you can just see this stuff in real time. Like this is what it looks like right now. Is anybody going to come vote? Come on, pull up. I need you to do that. We're in the middle of a show. Make it look good. All right, somebody just pulled a poll down. What's wrong? What if we caught something right here together? We're like, who is this person? What is this? Is that Liz Cheney? What's she doing in Arizona? All right, anyways, so we'll come back. We'll check that out, but you can see all sorts of videos are now published, and so we'll check in on the Dropbox story. And then, golly, this one was an interesting story also that came in from the Daily Mail today. Apparently, Tim Walz had a love affair with a Chinese communist. I had to do a triple take on this headline. What? I read it again. Kamala Harris's VP choice, Tim Walz, had secret fling with the daughter of a top Chinese communist official during a teaching stint in China. What? Yeah, no, it's real. It's the fourth time I read it. It's the real one. So, okay, her name was Jenna Wang. It happened back in 1989. I don't know how big of a deal it is, other than the fact that he's literally making love to communists. Oh, gosh. Well, you keep saying Kamala Harris is a communist. Why? Well, because Tim Walz sleeps with them. How about that? So that's one idea. But we'll go through it. It's new. It's another one. We know the Democratic Party has a history of this. Remember Eric Swalwell, that representative who made Bang Bang with Fang Fang, a Chinese spy. Now we've got Jenna Wang also here. So we've got these stories. I don't know what it is with the Democrats and CCP spies or whatever, but we'll talk about it. And then, of course, we will say hello to you and we'll see what you have to say about all of this and more. And it's a beautiful day, my friends. Glad you're here. You see, over the weekend, we added some new additions to the studio. We're in full-blown campaign mode right now. And we're excited about it. You can see just a quick tour. We have the fanny pack, Fannie Willis for justice, for Lady Liberty to govern America. So the fanny pack is there. This is the Trumpy bear. We've got some garden gnomes from our friend in Las Vegas. We've got El Presidente here and his nice portrait. We also have a couple hats. This one has the Trump hair on it. And then, of course, how could we forget Nathan's hot dog, Nathan Wade's hot dog. And the shirt, as we talked about last week, is from our friends at the 2A Republic. And orders went out today. Okay, they sent me, Michael, what's up, Michael? Sent me a message and a very grainy video, but showing him with a whole box of boxes that are going out. So if you ordered some shirts last week, if you ordered some gear last week, amazing. You're going to be getting those very soon. The link is down in the description below. And this is an operation with my friends, and they're real good dudes. So these shirts are made in America. They're very nice. They've got the flag over here. Very simple. All the Trump shirts that are sold, all the profits from the Trump shirts that are sold are going back into the cause. It's either going to be to Trump or to Elon's PAC, America PAC. And we'll just see where it goes. But we're going to give that back. But grab another shirt. There's other great shirts over there. And it is very Second Amendment oriented. And so check them out. They're real cool. These are good dudes. And so check them out. You're going to see me wearing it for a little bit further. In fact, since we're in the middle of an election right now, you may not even see this shirt leave my body. We'll see. That decision is yet to be made. But so check it out. Links are in the description below. And grab a shirt. We're having some fun. So hopefully you enjoy them. They're great quality. I totally dig it. And my Dark MAGA hat should be here today, too. It's going to be wild. All right. So we've got business to attend to, my friends. Without any further ado, let's get into it because we've got more election shenanigans afoot. Starting in Nevada. Late ballots will be counted in Nevada. That's according to the state Supreme Court. And this is very curious because we know there was another decision from the Fifth Circuit that said that ballots in Mississippi and Texas and elsewhere are counted on election day. If it comes in after the fact, those do not count. Why? Well, because there's a lot of constitutional precedent that explains why we need it on a particular day. It's in the law, it's in the statutes, and having it on one day makes it final. You don't give an opportunity to end the game and then have one team just taking shots on goal after the game is over, which is what the Democrats would like to do. So what has happened here is that the court has come down and they said, now get this, there have been other situations where the courts will say, well, as long as it was in the mail before the election ended, then it's good. So as long as you dropped it off like the day before, then the election happens, then your ballot gets delivered the day after the election. Like, okay, that's good in some locations. But now, no, doesn't even matter. Doesn't even have to be postmarked. If it's unpostmarked and it gets delivered 3 days after, not even in the mail, just shows up, it's good to go. Well done, Nevada. So again, the strategy would be to see what the difference is, the margin that you need to secure in order to reverse the outcome, and then go get those ballots and ship them in from overseas or from wherever else you need to generate them from. But the Democrats are quite good at this, and they did it in many other states. And if you missed the segment from our members segment where we were talking about the Mississippi ruling out of the Fifth Circuit, that is coming up soon. But in that case, the Fifth Circuit explained the litany of case law and prior precedent that shows why we need to have this stuff on one day. And so this ruling is out of sync with the federal courts elsewhere. But in that opinion, they explained how many other states have done this. And in fact, a lot of them did it during COVID. The case talked about 7 cases, and we covered most of them here, that changed the rules back during COVID so that they could increase the time after the election by which they could return ballots. It's happening again, and they're doing it right now in Nevada. In fact, they've won. So here's some background before we take a look at the decision. If full decision is here, we'll go through it to see what their contorted logic reveals. But here is what it says. It says the Nevada Supreme Court will allow state officials to count absentee ballots that arrive without a postmark as many as 3 days after the November 5th general election, rejecting a challenge brought by the Republican Party. So the Republicans say, no, you have to stop counting on election day. It's over. The decision on Monday is a setback for the national GOP and a big victory for Democrats who want to just flood the zone with extra votes. A majority of the Nevada High Court found that a state law allowing mail-in ballots to be counted, if the postmark date cannot be determined, applied to envelopes with no postmark at all. What if it doesn't have a postmark? No, it's fine. Court said it's fine. Republicans had said the law should only cover ballots where postmarks aren't legible. Well, if you can't see it, like if it's postmarked and it's like, well, I don't know what the hell that says, but at least it's a date, then you count that. But if it's no postmark at all, that now counts. It wasn't immediately clear how many ballots might be affected. The GOP offered an example of 24 ballots that were received by one county during this year's primary. But the case is part of a broader effort by Republicans, they say, to impose more restrictions on absentee voting and question the security of the process, which is a total disaster, as we know. And we've already talked about other lawsuits here where in certain states they're suing. I think Ohio was the one we covered. Ohio is suing the DOJ, or rather Department of Homeland Security, to get access to their databases so they can actually check their voter rolls against the citizenship databases that the federal government maintains. But the case is part of a broader effort by Republicans to impose more restrictions on the voting. Now, a spokesman for the Republican Party didn't respond to a comment. Nevada justices wrote in their opinion the following. Let's get to it. As you can see, it was the Republican National Committee and Donald Trump for president and the Nevada Republican Party versus the Nevada Secretary of State. And what you'll see here is the Nevada Alliance for Retired Americans. Anybody having 2020 flashbacks? Yeah, because that's what we saw all over the place. The Michigan Alliance for Retired Americans, Nevada Alliance for Retired Americans. These were the groups that we saw in 2020. They were all filing lawsuits against the secretaries. They would settle the claims, change the rules, enter into a contract, call it a settlement agreement, and then say that the state was bound by the settlement agreement, even though all of that was outside the law. Then the Republicans sue and say, you can't do that. You can't just interpret things to accept everything whenever you want from anybody you want. So here's what the Supreme Court says. Highest court in the land there says, this is an appeal from the district court denying injunctive relief in an election matter. Now, the Secretary of State's office, they tell us, through testimony to the legislature and a memorandum circulated to election officials, has interpreted this statute or this rule such that a mailed ballot without a postmark that is received by 5 p.m. on the third day must be counted. So the law says something. He says, the secretary says, well, yeah, my interpretation of that is I can take these ballots that late. RNC, Trump, Scott Johnson, they call them the RNC, bundling them together. They sued. They want an injunction. They say you have to stop these officials. Stop them from counting the mail-in ballots without a postmark that are received after the general election if they just print a bunch and ship them in. The district court granted a motion to intervene by Nevada and the retired Americans who opposed the motion. The state opposed the motion. They want to count the votes. After a hearing, the district court denied the motion, and they now appeal. So they talk about standing, first of all. Of course, that's where we go. They say the RNC argues that it has standing under resource diversion and competitive injury standing theories. And so we're going to review this to see if that's true. We must first conclude that the RNC did not demonstrate standing under a resource diversion theory. Saying the RNC says that it currently expends a lot of resources on election monitoring. We have to keep our eyes on these things, but it would need to expend additional resources to specifically monitor mail-in ballots that come in without postmarks. So we're going to have to invest a lot into this if you count these. But they say the RNC already monitors the elections, okay? So you're already going to have people there. So don't act like it's going to be a bunch of additional work, okay? You're already there. Accordingly, any additional resources would just be ongoing or business as usual. And so that's not enough for standing, meaning you're not harmed by having to do this. You're already there. Nor did the RNC allege that the challenged action affects their core business. And so the RNC lacks standing under that theory. So let's talk about the next one, competitive injury standing. They say, well, this one is also strained. It presents a closer call at this stage, telling us, assuming without deciding that the RNC has demonstrated competitive injury standing, we nevertheless, we'll say they do have standing, we nevertheless affirm the order denying the motion on the merits. So regardless of standing, we'll say maybe you do, maybe you don't, but we'll say you do, and we'll just address it. Now, a preliminary injunction, which is an order from the court, in this case, it would be an order from this high court telling the election officials, if they come in after the election, you cannot count them if they're not postmarked. So they say, okay, we have to review this. Now, this court reviews this for an abuse of discretion. Did the lower court screw up? They say the Republicans argue that it demonstrated a likelihood of success. Why? Well, they say, first of all, we're likely to succeed on this. In fact, the law says you cannot count the ballots received 3 days after Election Day that are not postmarked. And second, the RNC also argues that it was likely to succeed on its argument that the memo violated the notice requirements, right? So then the secretary comes out, he says, well, this is how I'm interpreting this. So he should give people notice so they can contest that, file lawsuits and other things before he takes action. So they tell us what the law says. In Nevada, the revised statutes provides, quote, if a mail ballot is received by mail not later than 5 p.m. on the third day following the election, and the date of the postmark cannot be determined, the mail ballot shall be deemed to have been postmarked on or before the day of the election. So that's the law. Now, this court is reviewing this. They look at the plain language of the statute. They say this is susceptible to two reasonable interpretations. We can say there's two things. One, which is the RNC's, is that the mail ballot must have a postmark given. Because when they say when the date of the postmark cannot be determined, well, that means there was a postmark, but you just can't read it. Right? That's what it means. It's there, but you can't determine it. Now, under this interpretation, subsection 2 applies only where the ballot has a postmark, meaning you only accept it when the postmark comes in, but you cannot determine it because it's ineligible or it's smudged. It got wiped off or something. So it's there, right? It's in the law. It says the postmark cannot be determined, not that it does not have a postmark. Now, the second interpretation, which is what the Democrats prefer, offered also by the state, is that this applies to ballots without a postmark entirely. Because they say, well, if it doesn't have a postmark, guess what? Well, then you cannot determine the date. So yeah, obviously you can't determine the date because there's no date on there. So cannot be determined. Now, the federal district court interpreted this, concluding that it established, the bigger concept was, it says it establishes a presumption that a ballot was cast in time as long as it's received by election officials before 5 p.m. on the third day after the election, even if it lacks a postmark. So what they're doing now is they're going to federal courts. So they say in this case, this is a federal court that it said, well, something very similar issue, maybe not the same law, but a similar issue. And while our dissenting colleagues note, as we're going to see the other court, the dissenters are unhappy about this, they say that the legislature could have clearly stated that it intended for subsection 2 to apply for ballots without postmarks, but the converse is true also. Meaning if they wanted it to count ballots that don't have any date at all, they would have said it. But they say, well, they could have also said that they could have said only applies to ineligible or smudge postmarks, so they could have been more specific the opposite way too. Now, because the statute could therefore reasonably be interpreted in two ways, we're going to look to the legislative intent. What did they intend to do? And this is where things get slippery, because then the court just substitute their intentions for the legislatures. Now, the legislative history is consistent with the interpretation proffered by the Democrats. For example, during a hearing on the bill, one assemblyman and the bill's sponsor was asking about the postmark cannot be determined provision. He says, I'm wondering why you believe it's good policy for us to accept mail ballots where the postmark date cannot be determined. And I'm wondering how, if we know how often that happens and where a ballot comes back without a postmark date. So they looked at the meetings and they look at the record and they say, he said without, which means cannot be determined. It's the same thing. Basically means the same thing. So in response, he explained that the intent was to allow any ballots received within the period, even whether they were not postmarked or the postmark was ineligible. And so they're literally talking about what these guys were talking about at the debate. During a later meeting before the Nevada Senate Committee on Finance, Frierson also touched on the broader purpose of the bill and saying that we conclude that the legislative history supports an interpretation that anything without a postmark will be counted. They also say public policy supports this too. As explained in the legislative history, the purpose of the bill was to expand the ways in which people can vote. Of course, including after the election's over. If a voter properly and timely casts their vote by mailing their ballot on, before, or on the day of the election, and through a post office omission, the ballot is not postmarked, it would go against public policy to discount that properly cast vote. So the post office is failing. Got it. So it's not that you're not getting it in the mail. It's that the post office is not postmarking it. Indeed, there is no principal distinction between mail ballots where the postmark is ineligible or smudged and those with no postmark at all. In each instance, the date the mail ballot was received cannot be determined. So it's the same thing. One is making sure that it actually was going through the postal service, right? That's the purpose. The legislature has accounted for difficulties in determining the date. The point is that it's in the mail. It's not being developed after the fact. It's a contemporaneous stamp that is something was chronicled. You did it. We also conclude the RNC's argument that it's within the voters' control to ensure that their ballots are postmarked is insufficient. There's strong public policy here. We have to win elections. The RNC asserts that a voter can ensure their ballot is postmarked by visiting a post office and requesting it. While this may be possible for some voters, it's not possible for everybody. And the statute doesn't impose that burden on them anyways. And so the RNC is demonstrated they're going to fail here. And so the RNC also argues that the district court made a mistake by saying they didn't give us proper notice of these changes. But the RNC saying that Republican voters voting by mail at a much lower percentage than Democrat voters, and so thus counting invalid mail ballots after Election Day would benefit Democrats at the expense of Republicans. Now, the RNC's complaint identifies various sources supporting its assertion that the partisan lean of mail ballots would favor Democrats, but the RNC did not present evidence as to the partisan lean of mail ballots that don't have a postmark. So the Republicans are saying this is going to benefit them if you let them have 3 extra days of mail-in balloting. You understand? Because that's what they do. So they can just deliver a bunch of stuff in the mail. I said, well, so what? You have to show that it's biased because you don't have a sample of all the ones without a postmark. And it's like evidentiary problem. It further failed to present evidence that the 24 mail ballots received in Clark County after Election Day without a postmark impacted any race. Okay, so it's no widespread fraud that impacted the outcome or that it would impact the outcome of 2024. So the RNC also fails to demonstrate a potential hardship on anybody. And so thus, because the RNC fails, we believe that the lower court did not err. And so ballots can come in even without a date in Nevada. So incredible. Signed by these 5 judges who, I'm sure they have got interesting backgrounds and records. But here is the rest of the decision. This guy is concurring. He says, I concur only insofar as I agree that they've made an insufficient showing that there will be irreparable harm. But I disagree that this allows for the consideration and the counting of mail-in ballots after election when they don't have a postmark. This is unambiguous, and so we need to look no further than the text itself, he says. When a statute is facially clear, we don't need to go beyond it, like this court did here. In Section 1, the statute is clear. A mail ballot must contain a postmark. In order for a mail ballot to be counted for any election, the ballot must be mailed to the clerk and postmarked on or before the day of the election. It says that. Must be, it's a requirement. In Section 2, the statute allows for an exception, but still requires the existence of a postmark if a ballot is received no later than 5 p.m. on the third day. If the postmark, right, it's there again, it's got to be there. It's clear. The postmark means it requires a postmark. Read together, the statute is clear, it's unambiguous, it requires the existence of a postmark. The exception cannot exist without the triggering event. In other words, a postmark cannot be indeterminable unless there is a postmark to begin with. To read otherwise contravenes the plain text of the statute. Under no reading can we omit the requirement that a postmark must exist. And so therefore, we need not inquire into the legislative intent. As I said, they go into legislative intent when they want to manipulate things. Like, well, we don't know what they meant. Yeah, you do. The majority's conclusion to the contrary runs afoul of our basic statutory construction principles. It's how we write the rules. And so we're not going to read implied terms into the statutes. The law's inclusion of a postmark requirement implies the exclusion of non-postmarked ballots. And it's like you timestamp your documents, right? You file something, you timestamp it. I was here at this time. Here, click, boom, stamp it. Right? When you post a social media post, it's stamped. Nobody cares about your predictions on the fight after the fight. I think this guy's going to win. Oh, congratulations. It's over. Nice job. We look back to, oh, you got that. You said that was going to happen before it happened. Holy moly, you're like a wizard. So same thing happening here. It's got to be in the mail because we had, for some reason, I don't know why we do it, but we consider the Postal Service to be some sort of competent agency that's going to stamp it at least. And so we'll know it was out of your hands at the time that mattered and in the custody of the state, even though it's not. It's in the federal government zipping around our U.S. Postal Services until it's in the custody of the state and counted. Now, if the legislature intended to include mail-in ballots that contain no postmark whatsoever, it would have done that. They could have included language allowing for an exception with an indeterminable postmark or no postmark. They could have added those 3 words in, but they didn't. Instead, the statute is clear that a mail-in ballot must contain a postmark. No mention of mail-in ballots that are void of postmark altogether even come in here. And so the majority is making a mistake erring in reading in the terms of that the legislature omitted. If we were to take the majority's view, the postmark language would be entirely unnecessary. And there would be no need for the language entirely. If the exception was meant to count mail ballots, regardless of any sort of postmark, illegible or otherwise, that met the relevant time requirement. And the mention of a postmark at all would be unneeded. That is, the language of the statute would simply accept any mail ballot that was received, even without a postmark. Just get rid of it. If you have it in custody, it's good. Don't even need to mention a postmark. But we must read the statute to actually give meaning to the phrase. And so in sum, the law is clear and unambiguous. A mail ballot must contain a postmark, and therefore any inquiry into the legislature's intent, whatever they were talking about, is erroneous. No one cares. What they wrote is what matters. We must read the statute as it is written and stop reading terms into the statute that they never put in there. If they meant to include mail ballots without a postmark, as they say, because you guys say they did, it would have done it, but it didn't. And we cannot read into the statute exceptions that do not exist. And so to do so contravenes our simple reading interpretation abilities. And because I believe the majority errs, I respectfully concur in the result only. And his is more of a standing problem. Same here, Pickering, same thing. I join my colleagues. The parties offer competing interpretations. While I agree with Justice Herndon, the guy just above, that the statute seems to say that it must be postmarked, that is not the argument that the appellants make. Instead, they argue that while the mail-in ballots do not need a postmark, ballots that arrive in 4 days must have a postmark to be counted. Now, while this reading may have a plausible policy justification, it does not comport with the statute. They argue that while mailed ballots that arrive on or before Election Day do not need a postmark to be counted if it arrives before, ballots that arrive in the 4 days following must have a postmark. Yeah, because the postmark is relating it back to them sending it before the election ended. So we know that they ended it when they were supposed to end. They didn't vote after the fact. While this reading of the statute has a plausible policy justification, it doesn't comport with the text either. It conflicts with the Secretary's interpretation, which instructs that mailed ballots that do not have postmarks will be counted so long as they're received. Now, he's talking about the injunction, saying, I would affirm the order denying the motion for 2 reasons. First, while I share the concern with the endorsement of the accepting ballots without postmarks, I am also not convinced that the appellant's reading is correct either. Under their interpretation, mailed ballots without postmarks that are received on or before Election Day would be counted, but those received after that date would not be counted unless they have postmarks. This is a distinction that they do not make, that the law does not make. Okay, that might be true. Our rules of statutory interpretation require adherence to that, absent ambiguity, which doesn't appear here. Second, and more importantly, it would not be in the public interest for the court to reverse that. Mailed ballots are already sent to voters. Voting's already underway. Court orders affecting elections are problematic. It's not in the public interest to change things this close to the election. And for this reason, while I disagree, I concur in the decision with the holding, signed by Pickering. So long story short, Nevada will be accepting ballots 3 days after the election. So election day, 1, 2, 3. And what we'll see will be anything that comes in is counted, essentially. Doesn't even have to have a postmark date. And it's a timestamp just to say, I voted before the end of the election and put it in the mail. So I shot the ball before the buzzer rang. But now there's no way to prove that. So now Democrats like the Nevada Association of Retired Americans and the Secretary of State and the intervening Democrats will all be able to see what the margin is. Oh, Trump's up by 10,000 votes. Great. Then they've got 3 days to bring in UOCAVA ballots, absentee ballots, whatever they need in order to close the margin and bridge the gap. So that is going to be very interesting. We'll keep our eye on that litigation to see what the Republicans do or say, whether they appeal it, but we're just days out from the election. So in all likelihood, this will not be changing, and we'll see litigation that might come up after the fact, after the election. But as it stands, those votes will be coming in and they'll be counting. Now, I don't know what's so complicated for Democrats. I don't know why we can't have an election that ends on Election Day. Well, we do know why. It's because that's how they want to win. We saw it in 2020. They're trying to get it again this time. We'll keep our eye on it, my friends. Thanks for subscribing and joining as we do. All right, now, let's jump over and see what's happening in Florida, because we got a big filing. Jack Smith on his heels again. Trump's defense team submitting their brief in the 11th Circuit. As we know, Jack Smith is trying to resurrect the classified documents case that was dismissed by Judge Cannon because Jack Smith is not a real boy, not a real prosecutor, was unlawfully appointed, and never should have been allowed to bring these cases in the first place. He's also misappropriated $36 million, stolen, give or take, and the numbers are only going up. So here, Trump's team is telling the 11th Circuit, Jack Smith should not even be here, all right? It's already been dismissed. It is from President Donald J. Trump, brought by his attorneys Emil Beauvais and Christopher Keese, two attorneys extraordinaire, sending this in to the 11th Circuit, appealing from Florida. You can see we got a bunch of stuff. We'll fast forward through table of cases and authorities and contents, and then we get to the introduction. In the 11th Circuit, Trump's defense tells the Court of Appeals, all right, judges, there is not and never has been a basis for Jack Smith's unlawful crusade against President Trump. For almost 2 years, Jack Smith has operated unlawfully, backed by a largely unscrutinized blank check drawn on taxpayer dollars. More than $36 million has been spent unjustly targeting President Trump, and Trump through unprecedented encroachments on executive power, with Biden wrongly and inappropriately urging everybody to lock him up. Trump only days before the filing of this brief as part of their election interference strategy. Man, that was a hell of a sentence right there. That's a lot of money. And as we've talked about, what multiplier does Trump have in order to respond to that? Is it a times 3 in order to respond? Is it $100 million bucks? Getting close? In order to respond to that, to build a defense team against a $36 million invested by the government? Might be more than that, might be 4 or 5. So it's a lot. Now, in the most thorough judicial treatment of these issues that exists, we're talking about Jack Smith being disqualified, the district court explained why Jack Smith and his actions violated our Constitution, namely the Appointments and the Appropriations Clause, and dismissed the case. At least one Supreme Court justice in the United States Supreme Court, 2 former attorneys general, Ed Meese and his friend, who administered the laws at issue, and several prominent legal scholars, like Watching the Watchers in our amazing chat, among others, support the same correct conclusions. Quoting a case called Morrison versus Olson, they say frequently an issue of this sort will come before the court clad, so to speak, in sheep's clothing. The potential of this asserted principle to effect important change in the equilibrium of power is not immediately evident and must be discerned by a careful and perceptive analysis. But this wolf comes as a wolf. Don't need to question him. Smith's unlawful appointment and conduct perpetuate all the evils that Justice Scalia's prophetic Morrison dissent predicted. And like presidential immunity, this appeal concerns issues that present risks to the institution of the presidency and will have enduring consequences on the balanced power structure of our republic. Now, while presenting little more than a regurgitation of arguments that the district court thoughtfully rejected, the brief of the special counsel's office offers casual and dismissive treatment of the serious separation of powers problems arising from Smith's unlawful appointment and funding. And they do so notwithstanding Judge Clarence Thomas, his explicit concerns. He wrote about this, that the appointment, he said, we must respect our Constitution's separation of powers in all forms, else we risk rendering its protection of liberty a parchment guarantee. In order to prevent that danger from coming to fruition, this court should affirm the 11th Circuit. The Appointments Clause and Jack Smith requires that officers are appointed by law. No law supports Smith's appointment. That's why their brief starts by emphasizing one single sentence from Nixon that cannot even qualify as anything but unreasoned, unpersuasive dictum. Moreover, even if Jack Smith is a valid officer, which he's not, he is a principal officer, not an inferior officer, in light of his lack of supervision and nearly unlimited jurisdiction and tenure to do whatever he wants. But he has not received the required presidential appointment, followed by advice and consent of the Senate. And finally, the terms of the permanent indefinite appropriation do not apply. So Smith's expenditure of tens of millions of dollars of public funds is also unconstitutional, and we need a refund. This court should affirm. So here's the statement of the case. They tell us. Let's go through it. On November 18, 2022, just 3 days after Trump announced his candidacy, Merrick Garland from the DOJ came out, and he purported, didn't actually do it, to appoint Jack Smith as a special counsel to, quote, prosecute federal crimes. In the appointment order, he cited these different statutes and said that Smith is subject to the Code of Federal Regulations. Now, according to publicly available statements of expenses, Smith's, quote, office has spent $20 million here and another $16 million here. They've not disclosed any of their expenses for the last 7 months. I'm sure the number is in the many millions. It's election season after all. He's got a lot of appendices to drop on Chutkan's doorstep. Now, the district court's dismissal, they say, after approximately a year, we're in Judge Chutkan's Cannon's case, the classified documents case, after a year of litigation over their discovery failures and their unprecedented disregard of the Presidential Records Act and their related motion practice over Jack Smith's constitutional violations, the district court held that Jack's prosecution of this action breaches two structural cornerstones of our constitutional scheme. Judge Cannon said violation of the Appointments Clause and the Appropriations Clause. The district court then, Cannon, concluded that none of the statutes that they cited gave him legal authority for his appointment, nor do the statutory arguments or their inconsistent history of the application of those statutes or the reliance on out-of-circuit authority does it convince Cannon otherwise. Now, separately, the court identified compelling reasons to conclude that Smith is a principal officer, which would also violate the Appointments Clause without question. He's basically a one-man department. As to the Appropriations Clause, Trump's defense says the district court held that Jack's investigation has unlawfully drawn funds from the indefinite appropriations slush fund that the DOJ set up. So Trump's defense continues. In the 11th Circuit, their argument begins. All right, Your Honor, Jack Smith was not appointed by law. All right, there is no law. A grant of inferior officer appointment authority requires explicit authorization and permission from Congress. Nothing short of that will suffice. Congress has satisfied these requirements by explicitly providing for this under the rules. And these are the rules. This is how they appoint people. However, none of those provisions that we just cited authorize Merrick to appoint a private citizen named Jack as special counsel to target Trump by using power that exceeds the authority of U.S. attorneys who are, in fact, presidentially appointed and Senate confirmed. Everybody else has to go through those checks and balances in order to be a U.S. attorney and prosecute someone. Not Jack Smith. They just brought him over from Europe. The statutes cited in the order, Merrick Garland came out. This is why I have power. I'm invoking this law and this law and this law. None of them passed muster. They are of a general nature, said Supreme Court Judge Justice Thomas. They're generic. They refer to attorneys from offices created by some other law. This section relates to the FBI. It's a weird place to hide the power to appoint a special counsel to prosecute a former president anywhere, anytime. None of those statutes gives Merrick any independent source to appoint him, and none at all. Now, the enactment histories of these and other provisions confirms the district court's conclusions. History lesson. Dating back to the Civil War, attorney general appointments outside of counsel focused on providing assistance to local federal prosecutors. Now, today, that authority is set forth in a statute, which they're relying on. There are several instances where Congress expressly provided for special counsel type appointments. In fact, in 1924, during a period that Jack Smith falsely mischaracterizes as involving widespread appointment practices consistent with the current appointment order, Congress passed a very specific law calling for the appointment of a special counsel to investigate the Teapot Dome scandal. Jack confines that episode to a single footnote. In 1978, Congress passed the Independent Counsel Act, which led to the authorized appointment of a special counsel, but that expired in 1999. Now, to the extent that Jack has identified exceptions, they are outliers. Watergate investigations are one example, but heavy congressional involvement in those appointments, which did not occur here, mitigated separation of powers concerns. Watergate spawned United States versus Nixon, where the Supreme Court assumed in a single sentence, without any analysis on an uncontested issue, which mischaracterized the statutes actually cited in the relevant appointment order, that the same provisions the AG cited to appoint Smith were adequate for the task. Wrong. The Nixon dictum is unpersuasive and it's non-binding, as are the out-of-circuit cases that applied it. And so Congress cannot acquiesce to Appointments Clause violations. Constitution doesn't allow it, but Congress did not acquiesce. They focused on a different issue. In fact, beginning with Watergate and for more than 20 years, Congress prioritized independence of special counsel from the executive branch. That's why they created it. That priority, along with the explicit appointment mechanism provided for the Independent Counsel Act, diminished the focus on other statutory authority for inferior officer appointments. Now, although no explanation is necessary, this contextualizes Congress's failure to expend political capital on potentially unpopular actions to rein in its criminal investigations in the manner accomplished by the district court's absolutely correct decision. The dismissal from canon should also be affirmed on the basis that Jack's role violates the Appointments Clause because he operates as a principal officer without presidential nomination or Senate confirmation. Smith has operated without the type of oversight and accountability that are the hallmarks of inferior officers. He's basically a one-man show, unless and until removed. The duration of his tenure, up to him. His expansive jurisdiction is bigger than U.S. attorneys. They're principal officers, and he has more power than them. He can operate in multiple districts. He can actually use them as force multipliers by making referrals to them. And finally, Smith also violated the Appropriations Clause. In addition to relying on 16 million stolen American taxpayer dollars, he's also stolen another 20 more from a 1987 slush fund they set up for the Independent Counsel. He meets neither requirement to get that money. The appropriation also requires that Smith actually be independent in the particular rigorous sense that attorneys that were appointed under the Independent Counsel Act, which is now expired, was creating safeguards to make sure they are more independent. He fails that standard too. And so he's not even meeting the standards necessary to get the money under the old standards, which are now void. So here's more of the argument. And we're familiar with these, so we'll hit the highlights. But it says, Smith was not appointed by law. Okay, there is no law. It's undisputed that we need a statute from Congress. Other recent decisions establish that. We need a clear statement from Congress will suffice. And there is no clear statement. None of the statutes cited by Merrick Garland or Jack Smith appears to create an office for the special counsel, and especially not with the clarity typical of past statutes used for that purpose. Justice Clarence Thomas, in a concurring opinion in the Trump immunity decision. Clear statement rules apply when it implicates constitutionally grounded norms that we would not expect Congress to unsettle lightly, right? If Congress is going to change something pretty important, they got to say so. The appointment order here was no everyday exercise of federal power. Are you crazy? A private citizen cannot criminally prosecute anyone, let alone a former president, unless they're duly authorized to do so by the American people. How do we do that? We elect someone. That person then appoints someone, and then that person is confirmed by the Senate. The AG named a private citizen to target a former president and the leading candidate based on official acts pursuant to using his exclusive executive power at a time when that former president was campaigning to take the White House back from Biden's boss, Garland's boss. Therefore, there is no clear statement from Congress, and we need one. Jack doesn't have it. Congress has also provided for many other appointments, but not Jack Smith's. Their effort to concoct a statutory basis for Smith's appointment contrasts with other statutes. Many other statutes do appoint people. Several provisions track the principal officer language. Congress has repeatedly demonstrated that there are certain appointment powers, but they don't rely on any of those explicit provisions. Instead, they rely on the separation of powers. They ask the court to authorize something the statutes don't say. This section did not authorize his appointment. And they go through a lot of history here. Section 515 is not an independent source for the power. All this did was create territorial flexibility. It provides that the AG and two other categories of attorneys with authority to conduct proceedings. That's it. You don't get to appoint and create new offices. And any predecessors also didn't establish appointment authority. In 1903, a federal district court held that the revised statutes did not authorize an attorney to participate in grand jury proceedings. Similar to the reasoning here, the court pointed to the provisions that specifically authorize the appointment of officers. And an old case is mirroring this case. And so Congress passed a law that mirrors that. A lot of history here. Same thing with Section B. There is no textual basis for the claim that retained is synonymous with appointed. The only authority they say is from 1883, where they're talking about appoint and employ. And that's really doesn't really matter. It's kind of the same thing. But this section doesn't create the power to issue a commission, much less an appointment. So it doesn't include it in there either. That argument does not establish the authority to undercut Cannon's reasoning. And again, a lot of grammar interpretation. What does this all mean? They say 515, you cannot say Jack Smith is legitimate because he's a special attorney. The term special attorney is referencing special attorneys only for specific purposes. And they say Jack Smith is not that because it's not a special purpose. He was not appointed to assist a U.S. attorney. They talked about that, so he's much broader. That power, special attorney power, goes back to 1861. It's somebody who is assisting the district attorney. It was transferred to the revised statutes later. Over time, Congress provided for other types of specially designated attorneys, but it's not an appointment power. It's to go hire and work with other attorneys to work with you. Similarly, it goes on. Other cases are showing that the language matches their interpretation, not Jack Smith's Section 17, the predecessor, even going back before the current version, right? Where did this come from? The Senate report also demonstrates that Congress was attentive to the Appointments Clause, and they viewed the paragraph as did not view the paragraph as creating the appointment power. Similarly here, this section applies to the FBI, applies to the FBI's people, not Jack Smith. Jack is a group of lawyers, not a group of prosecutors. So that does not cover him. His power should be in the DOJ provision, not in the FBI provision. Now, in response, Jack Smith's office largely regurgitates the inopposite statutory citations that we've already distinguished here. The context of this says it's not valid. It's for the FBI. It's not for him. They wouldn't tuck in special counsel in the middle of the FBI when there's a whole DOJ section. Justice Thomas observed, this would be a very curious place for Congress to hide the creation of an office for a special counsel tucked away in Christopher Wray's pockets. All of the numbered paragraphs are also saying this is FBI stuff. This is a curious place to shove that in there so he doesn't have the power. Now, fast forwarding. In 1909, in 1933, in 1935, it goes on. And then they created Section 533 eventually. And the Justice Manual says it's for the FBI as well. So 533 is not for the special counsel. It's for the FBI. 509 and 510 also didn't support Jack's claim. These are generic provisions. This is the function of existing DOJ officers and agencies. 510 authorized the delegation of any functions to existing other officers. So yeah, you can delegate powers and duties. You can delegate them to officers, but the delegation power does not equate to the appointment power. The new argument relies on a series of inferential leaps with no legal basis. Surprise. The AG was not free to hire Smith as a non-officer employee and then elevate him to this. You can't hire him to get your coffee and then all of a sudden, oh, well, you're promoted now, and say that doesn't violate the clause. There would be no need for that language if they could just do that and make an end run around the Appointments Clause. So the historical discussion that they brought up, again, is inaccurate. Truman's reorganization plan for the DOJ is missing key aspects of that process. Truman's message was that the DOJ plan lacked any suggestion about broad new powers. If Johnson had those powers, someone forgot to tell him. He sought approval for new boards. He sought congressional approval for the establishment within the DOJ of new people, new officers. He wouldn't need to request that if he had the power already in his agency, in his executive branch. So nobody else has exercised power this way, obviously, except Jack. Now, their remaining historical arguments fail. His selective history of prior special counsels does not confirm the legality of his appointment. Yeah, there's a turbulent history of here because there's a bunch of different laws. Over time, political pressures produce special prosecutors. Teapot Dome scandal, 1924. There was advice and consent under the Appointments Clause. Justice Thomas pointed out that the Independent Counsel Act is another example where Congress expressly provided for a special counsel. They said, yeah, like here's an act. Here's a new position. So why didn't they do that for Jack? Consequently, as discussed in more detail, the historical record is insufficient to warrant that they can utilize this power. They've got a whole series of cases that came before Watergate. The pre-Watergate cases have had a lot of developments. They cite congressional debates. They talk about the Truman administration, Watergate, where they were talking about securing independence of attorneys. Archibald Cox comes in here. Lot of detail in this brief. So we're fast forwarding through just to see what the main bullet points are. No binding or persuasive authority supports his position either. And this is all dicta. We're not in the Fannie Willis case. This is the classified documents case. Special counsel says that it was critical to their holding. The Nixon case, Trump's people say it was dicta. I hardly knew him. Nixon contains only a passing reference that is even arguably relevant to this case. There is no validity of the statutory authorization of the regulation appointing Cox. In Rudolph, another case, and another case, and another case. So they're saying you have to follow Nixon. They demand blind adherence to this. It's an unreasoned statement that's not even applicable here. The dictum appears to have been lifted nearly verbatim from a conclusory assertion from Jaworski's brief, which they didn't even talk about. And so the district court was well aware this is dicta, and there is Supreme Court dicta. And so any opinions that are based on Nixon are also not persuasive because Nixon is bad. Now, for all the reasons, you should find that Judge Cannon was correct. Jack Smith is not appointed by law. And if he's not appointed by law, everything he's doing is unlawful. Therefore, dismissal was also appropriate. Smith is not subject to any oversight. His jurisdiction is too broad. He's not an inferior officer. The district court discussed these at length and found them to be compelling. First, he has the full power and independent authority to do whatever he wants as a U.S. attorney. Those are all principal officers. He's not. Regulations also say that they can remove people in the DOJ, but he will not be subject to the standard oversight, and that coordination with the Biden administration is, quote, non-existent. Similarly, he has more protection against removal than other people, and there are no meaningful limitations on his tenure. And so for all these reasons, he is clearly a principal officer, and he's stolen funds. He's been relying on a blank check from an indefinite appropriation slush fund. They require that money to be used for the designated purposes, and those designated purposes were for independent counsels. He's not that. He spent $16 million here, $20 million here. And the district court expressed concerns about the appropriation, saying that money was for independent prosecutors. He is not completely independent of the DOJ. The restrictions are not consistent with the standard that money was for. That's why there is tension between his office and the money. His lack of sufficient independence for the money, which required independence, is a problem. The Government Accountability Office found Fitzgerald to possess the level of independence necessary because he had no supervision or control of anybody in the department. But that is not Smith's case here. And so all of his money is now stolen, and so therefore the court should dismiss the case. Signed by Trump's defense team, Todd Blanche, Emil Bove, Christopher Keese, going up to the Court of Appeals at the Court of Appeals in the 11th Circuit. They say this court should affirm. Make Jack Smith go away. He was not lawfully appointed, and this is going to be a fun one to watch. So we'll keep our eye on it and see what the Court of Appeals does and how they rule. Now, whichever way they go, there's always, of course, the Supreme Court, which will be the next step. We already know Clarence Thomas has hinted where he falls on this. Would this also be convincing enough for the other Supreme Court judges, or will they do what they can to try to salvage this position? Because if this sticks, then the DOJ's power to appoint special counsels and exploit this open hole in our government will go away. And so Congress will need to act. Or if this goes up to the Court of Appeals, I think there's a circuit split right now. So the D.C. court has said that Jack Smith is a real boy. Florida said he's not a real boy. So we've got a Court of Appeals in D.C., which is now being set up for a potential Court of Appeals split. In this case, if they agree with the Court of Appeals, then Trump can take this up to the Supreme Court, and then the Supreme Court can lay down a rule for the whole country to follow and then connect and make some uniformity amongst the lower level courts. But very interesting decision. Jack Smith has spent millions of dollars, caused Trump to probably spend $100 million in response, not to mention the, $1 billion of damage that the political stories that have emanated from these fake prosecutions have caused. It's been a weaponized prosecution from the inception. It's brought by a private citizen who's not even a real prosecutor. And so hopefully the 11th Circuit finds accordingly. We'll be here continuing to cover it. Thanks for subscribing, my friends, if you haven't already, and we'll look forward to seeing you back here on the next one. All right, and my friends, we got one final segment on the day, starting here. Dropbox fires, ballots up in flames in various places around the country. In Arizona, we had a postal service Dropbox that caught fire. There were some ballots in there, but it was a small number, a handful. This is an actual official ballot Dropbox, and the numbers here are much higher. You can see ballots in fuego. Not good. Don't want them to be on fire, generally speaking. The story comes from the Mirror. You see some photos here. Hundreds of ballots are now lost in a suspicious Dropbox fire, Washington State and Oregon State. Ballot was at Fisher's Landing in Vancouver, smoking early Monday morning. Photos were obtained by ABC affiliate KATU. Dense gray smoke pouring all over the place. Several police units converged. It continued to smoke. The outlet reportedly captured first responders, several burning ballots. According to the auditor, hundreds of ballots were in there at the time. Last collection was 8 a.m. Sunday. Only a few ballots were saved. The auditor urged anyone who dropped off a ballot to immediately request a new one. And here's another image. It says, we're going to change our ballot retrieval process so that ballots are picked up in the evening, leaving fewer drop boxes overnight. Earlier this month, ATF received a report of a suspicious device found near a ballot drop box. No injuries were reported. The ballot fire in Vancouver came hours after Portland police responded to another ballot Dropbox fire where investigators believe that an incendiary device was used. Is somebody just throwing an old cigarette in there, a box of matches, or an incendiary device? A bomb? Is that a terrorist attack? According to reports, the fire was reported around 3:30 a.m., only put out by security before the firefighters arrived. A report indicated an incendiary device had been found and it was later cleared. However, the police is still investigating. Officials have yet to give word on the status on the ballots inside there. So they're asking if you're in Portland, you know anything, talk to somebody. Portland FBI released a statement. They said the FBI is coordinating with federal, state, and local partners to actively investigate the two incidents in Vancouver. Anyone with information, please call us. And of course, they're saying Trump is mean. He's posting inflammatory statements. So that was the story. Here's what MSNBC was reporting with some video.
Breaking news from the Pacific Northwest. State election officials are working to determine how many ballots were destroyed overnight after two apparent arson attacks. Drop-off ballot boxes were apparently targeted in Vancouver, Washington, and Portland, Oregon. Police found an incendiary device, that's their frame, inside the Portland ballot drop-off box. County elections officials say fire suppressant inside the drop box protected nearly all the ballots. Only 3 were damaged. But officials in Vancouver fear that hundreds of ballots could have been damaged or even destroyed. It is not clear if the two are connected. The FBI is investigating. Breaking news from the Pacific Northwest.
So that's happening there. In Arizona, as you can see, your boy voted, dropped off a ballot. And I was under the impression that our ballots were indoors because mine was indoor. But there are also ballots that have outdoor drop boxes that look just like that. And so you can see there is somebody else coming up to drop a ballot off. And so that person is right there. And in it goes. So that's in Phoenix. This one is in Mesa. And this one has folks walking up there. And that one's outside. Now, the one that I was at earlier today was inside of a building. You can see that's the building that I was in. And I was walking around there. That building right around the other side there when I was up over this direction. Let's see. Anyways, that's where it was inside of a building. It did not look like the other ones. This is certainly, okay, so we see what that is. This must be an arm. I'm like, what is this thing? It must be a parking arm. It's going up and down. See that? Going back down again. All right, so if somebody rolled up on that and then dropped a book of matches in or something, you'd probably be able to identify who that person is. Here's another location. You can see it looks like people are just parking. And Mesa Dropbox, this is their close-up view. So they should have a bunch of cameras on all these things. Who dropped the ballots in there before they went smoldering. And there's a bunch of other video in Arizona. So if you're interested, you can see here's ballot processing view number 1. It's happening right now in Arizona. We're always looking for Liz Cheney or Jenna Griswold or Jocelyn Benson. It's like finding Where's Waldo. If you see Jocelyn Benson or even Stephen Richer or any of these guys, now he might supposed to be in there, but just for, whoa, what's he doing in there? Start to get a little nervous, you know. Anyway, so they're there and they're working hard. Shout out to our election workers, our poll workers. We got some amazing people who are dedicating their time, making sure the votes get counted. So shout out to everybody who's working hard over there. And let's see, we've got early ballot processing storage. So if you voted, there's your ballots. Oh, hey, there's mine right there. I see it. That's the one that's going to save America. It's right there, right front and center. Count it, baby. All right. So it's happening, my friends. We're right in the middle of it. Hopefully you're getting your ballots in and getting your votes in. Okay, here's 2 people. All right. Yeah, well done. You made it. 2 votes in. Don't know who they voted for. And we won't speculate. But that is what's happening in Arizona. So keep your eyes on what's happening in your local states because things are getting squirrely out there. And we'll keep our eye on it. But now, let's talk about this story. Kamala Harris and her vice presidential choice, Tim Walz. Apparently, this guy had an affair with a Chinese communist. This story just broke today. Says Tim Walz had a romance with Jenna Wang, daughter of a CCP official, back in 1989. So it's old. Back during his weird times in China. We don't really know what he was doing over there. But now this adds another piece to the puzzle. We were all asking ourselves, why does somebody go over there 35 times? This is a good reason, because he's in love with a woman, with a communist, and he's a communist. So they probably thought they were going to make little communist babies and live happily ever after. But at least people had some other interesting theories out there, right? Like, what else was he going over there for? At least it's an adult woman, a 25-year-old woman. Like, that's good news. Could have gone a number of different ways there. That's a little bit of a surprise, actually, but it's good. All right, so Tim Walz had a secret fling with the daughter of a high-ranking communist official during his 1989 teaching stint in China. Daily Mail can exclusively reveal Jenna Wang, now 59, claims the VP hopeful showered her with gifts and seduced her at his pokey staff accommodation. Whoa. What does that mean? Pokey staff? Like making fang fang? Anyways, the lovers could not risk holding hands or showing affection in public because Wang's dad was a high-ranking figure in the Chinese Communist Party. Would disavow her if he knew. But their romance blossomed behind closed doors as they sipped tea, made love, and listened to George Michael's hits, leading the then 24-year-old Wang to dream about marriage and a new life in the United States. Sounds like a happy story, but it gets bad from here. No proposal was forthcoming from future Minnesota governor, though, and the shame of being treated, quote, like a prostitute eventually left Wang feeling angry and suicidal. Not good. So there's Walz and Wang, I guess. Here she is. Old photo, new photo. She's now emerging. Tim was very passionate, she said, and very romantic. I can still remember dancing with him to our favorite song called Careless Whisper. Anyone know that song? The fact that we couldn't touch or kiss in public just made it all the more exciting and intense when we were finally alone. We were deeply in love, and I wanted to marry him and start a family. When it didn't happen, I felt very unhappy and sad. Tim's behavior was very selfish. Walz's time in China is already a source of controversy. Of course, we already know he lied about being there for the Tiananmen Square protests. It later transpired he didn't join the staff of nonprofit World Teach in China until August. It was several months after he arrived in Foshan that Walz is said to have fallen head over heels for Wang, a pretty highly educated English language teacher at the nearby No. 8 middle school. She was attending one of his lectures to brush up on her pronunciation when the 25-year-old Walz slipped her headphones aside and whispered into her ear. That's a pretty bold move there, Timmy. He walked right up to her and pulled that ear off and said, "You're very beautiful." Well, it's pretty aggressive. Some women might report you for a crime for that these days. Tim was very handsome. I loved his eyes and his big mouth. We talked afterwards, and he was very complimentary about my English. Wang told the Daily Mail. There's Tim. He's over there. There he is again. That must be her. Is that her? Here's another photo. She must be providing all these photos. So is that him? Is she in this photo too? All right, I will try to point her out. My colleagues couldn't speak whole sentences, but Tim told me that if he closed his eyes and listened, it was like being back in America. Wang had a friend of the same teaching staff as Walz. Over the weeks that followed, the lovebirds grew closer, walking in the park, going to dances. They avoided overt shows of affection in case it got back to her father. Walz would travel to Hong Kong and Macau on the weekends. He couldn't sing, and when he tried to dance, he found it very hard. I could tell he was in the military. But we talked for hours and hours. We stayed in bed. We had intercourse. He continued to buy me gifts. I could never stay overnight because of the social conventions. It was very repressive. Couples walked around the cities like robots. My father would have been very, very angry and sad if he had found out. Jenna is the daughter of a CCP official, Bin Hui, who died in '99. There's Jenna on the beach in South China when she visited with Walz. During the summer, Walz returned to the U.S. but wrote letters to Wang, giving vivid depictions of his life and his teaching job in Nebraska. At Walz's direction, Wang says she sent off a passport photo and info about herself to an address in the States. Believing it was part of the process, Tim said, "I'll bring you over on a visa." When the future running mate of presidential hopeful Kamala flew back to China in '92, she resigned her coveted teaching role, believing she was about to embark on a new life to America. Now, their relationship soon began to sour, however, when Walz made clumsy romantic gestures in public. And on one occasion, trying to feed Wang a slice of pear as they embarked on a 10-day tour of South China. People were staring at us. I tried to reject it because I was very afraid. Teachers were supposed to set an example. The couple made sure to book 2 hotel rooms whenever they stayed out on an overnight train. even though Walz insisted that Wang sleep in his cabin. The conductor shone a flashlight on Wang in the middle of the night and started to admonish her, only to retreat when Walz, afforded more respect as a Westerner, woke up. When the pair reached the island, known for its tropical climate and beach resorts, Wang was ready to confront him about their future plans. There is not Tim Walz there at the Tiananmen protests. Walz responded by suggesting that Wang was more interested in a U.S. passport than marriage. It was very offensive. I said to him that it is both or nothing. I wasn't giving up my life and position to move to Nebraska, a cold place in the middle of nowhere that most Chinese people had never heard of. I was giving it up to be with Tim, to get married and to start a family. Knowing now that he wasn't going to marry me made me feel cheap and common, as if I was being treated like a prostitute. The next morning, Wang slipped out of their hotel, took a taxi to a remote cliff top, where she says she contemplated throwing herself off the cliff rather than returning to her old life in disgrace. Wow. But on the bus back to Foshan, she resolved to leave Walz, instead headed to Gillen to help her mother recover from a stomach surgery. The bus stopped, but I didn't get off. He said, "Please come and let's talk. Let's give this a chance," Wang recalled. But I said no. I felt dead inside. I wasn't going to force a person to love me. I never saw Tim again. That was it. From 1993, then Walz began leading annual summer trips back to China. He married Gwen, a teacher, in 94. They never crossed paths with Wang again. Says they last exchanged a pair of friendly messages over Facebook in 2009, talking about how their lives had panned out. The mother of one says she's coming forward now because she feels Walz behaved selfishly towards her and put her reputation and career at risk with his fickle behavior. Said Tim lied about Tiananmen Square, and he's lied about other things. This is a crucial moment in history, and a man like this does not appear to have the character and the integrity to do one of the most important jobs in the world. And the Harris campaign has not responded. So another story, old story about Tim and China, actually makes a lot more sense now why he was going over there all the time, because he likes Chinese communist women, I guess, and was feeding them pears and almost getting them killed. So another interesting story. Very curious that it breaks last minute. Don't know that it's going to rattle any people on the left. I think they're probably giving him high fives on it. At least it's not an underage person or a CCP spy like Bang Bang and Fang Fang, like Fang Fang with Bang Bang. Eric Swalwell, you know him. So we'll keep our eye on it, my friends. Thanks for joining us as we do. All right, so if you're just joining us, we had 3 segments here today. We talked about a new order in Nevada from the Supreme Court of Nevada that says that they will accept votes even after the election is over. Isn't that fun? So get your votes in anytime you want over there. According to their Secretary of State, it'll count. Doesn't even need to be postmarked at all. As long as it's in hand, it's good. Then we read through the brief from Trump in the classified documents case. Judge Cannon has dismissed this case, but Jack Smith is scrambling to maintain his relevancy and wants the case reinstated. Of course, Trump does not want it reinstated. That brief has been filed, and we'll keep our eye on that one. And then lastly, we talked about these fires and these Dropboxes, and we'll keep our eyes on those as well. You can see what's happening here in Phoenix. Is this guy going to vote? No, he's not voting. Let's check over here. This person going to vote? All right. Let's see. All right, let's see. Okay. Taking a picture of the vote, of the ballot, just to make sure. Get that ballot in there. Nailed it. Perfect. Nailed it. Great job. Well done. See how easy it is? Get your votes in, my friends. Get your votes in. Hopefully that was a Trump vote. Not optimistic about that one, but all right. We'll see what you say about that, my friends. Let's see who's here and joining us. It's a beautiful Monday. I hope your weekend was outstanding. Thanks for joining us. Thanks for supporting us. Thanks for grabbing a shirt. Thanks for getting your vote in, doing all those amazing things. I see some of our friends are here. Very nice to see everybody. What's up, Shane Sousa? We got Lawrence here. Holy F is here. Donut. What's up, Donut? Tedsko. Scoop is voting on election day. Amazing. As long as you're voting, we just want to get those votes in. Anytime before the election, unless you're in Nevada, then follow the local rules. What's up, Eric Scorpio? What's up, Donut? What's up, Dog Digger? Good to see you. I see C. Reed Boopsies in the house. Yeah, no, don't throw matches in there. Yeah. It's a beautiful day. We had some great donos and great comments that came in. Thank you, Donut, for clipping for us. It looks like we got some new membos. Sheila Poo is here with new membos. Sheila Poo is bringing in 5 new membos. Why did I say 8? It's never 8. Ever. Never. Hey, Sheila Poo. What's up, Sheila? Look at this. 5 new membos are here. We got Debbie Washington, Dogma in the house. What's up, Dogma? John in Iowa, welcome. Acid Burn, Leon Lately, and Conservative Mama. Gifted membos courtesy of Sheila Poo. Thank you, Sheila, and welcome aboard, new friends. Hey, 5 more from Sheila. We got David Suits, Tracy Collins, Poor Papa, Hybrid Harry, and Skit Bra in the house, courtesy of Sheila Poo. 10 membos, courtesy of our friend Sheila Poo. A million hugs to you. Thank you, Sheila. We got Michael Wynn. What's up, Michael Wynn? Look who's here. A new membo. Michael Wynn became a membo. Lenny Malley says, if you're here, my friends, please smash the like button. Please like and share and subscribe. Share on all social media platforms. And God bless you all. Thank you for that, Lenny. God bless you back, brother. Wild Things Forever says, Rob, why is it that a judge rules in favor of no counting votes? Right away, another judge reverses it. Can another judge just reverse it back? I think, well, you're right. That does happen a lot. Although I thought judges don't get involved in election cases, no standing. Why not just get another judge to reverse it again and again and again? It just doesn't seem to make any sense. Why does the final dementia judge always win? Why can't Republicans ever have the last say? Well, sometimes we do. Yeah. So for example, on the immunity decision, that is one where Democrats would say the Republicans had the last word. But what we're seeing is things working themselves up to the top. Nevada was a state level Supreme Court, so that's the highest there in that state. The Mississippi case that we read this morning, Wild Things, was in the 5th Circuit. So it's not until something reaches the top that the Supreme Court can settle it for everybody across all the states. Right now, everybody's kind of doing their own thing on a lot of these issues. What's up? Milo Phone Bill says, no time to even lurk. Harris and Walz are suing states for requiring voter IDs. Which states? State or federal courts? Why did I bother getting naturalized? Well, because you're a good person, Milo Phone Bill, and you're trying to, do things right. Kamala and the Biden Democratic operation is not sustainable. We appreciate you being here. DeHook says, I'm sitting right behind the podium, my friends. DeHook. Are you at a rally, DeHook? Well, hopefully there's a good one going on right now. Schlista says, what's up, Schlista? I'm a poll watcher for the GOP. In my training, I learned in Virginia, thanks to the previous Democrat legislature and governor, we no longer require voter ID. They can just sign a note saying they are who they say they are, and you aren't allowed to verify it, even take their photo, so there is no way to prosecute them afterwards. So the sworn statement means nothing. Yep, exactly right. Thank you, Schlista. Yeah, you register with a fake name, fake address, fake ID, whatever, fake numbers, just sign the affidavit. They don't even need ID, right? Just a fake number, fake name. You're good. Sheila Poo, no postmark wasn't sent via mail. It shouldn't count. Exactly, right? How do you know it wasn't just some guy with a trunk full of ballots that just filled them out and delivered them? Ollie, what's up, Ollie? Bringing in 5 membos. Thank you, Ollie. Jason Alatorre is here. Eddie Ramirez, Warren Heyman, Jeffrey Adams, and Chris Blanchard, gifted membos courtesy of Ollie. Thank you, Ollie. And we have this image for you, Ollie. I don't know what's going on there, but what's up, Ollie? Hey, Cindy Jensen. What's up, Cindy? Thanks for becoming a supporter. Grab that morning stream. So new membos, grab the stream from this morning. It was a good one. We covered the 5th Circuit case this morning. Knox, what's up? Hey, happy Monday, all. Nice shirt, Robert. I'm starting to see a pattern of the low IQ celebs that are supporting Harris. Namely, it all goes back to stupid P. Diddy. Was he arrested in order to pressure people like Usher, Bad Bunny, and Lizzo, and Eminem and others? We all asked about the timing of his arrest. Was it the start of a blackmail pressure campaign to campaign for Kamala? It certainly feels like that. A lot of people are noticing. And the biggest one I thought was Usher, because Usher was on The View and he's like, well, I'm not really voting for Kamala at all or whatever. And then Diddy happened and now he's like doing backflips for Kamala. That's a weird one. Definitely. Good to see you, Knox. Hopefully your week's off to an amazing start. Thanks for saying what's up on the shirt. Will Crump, I pray immunity does not shield these blatantly partisan hack judges from bad faith, intentional, blatant election fraud. We'll see how that one goes out, Will Crump. They've got some very strong immunity. We'll see what happens. Sheila Poo says, if Postmark fails to postmark the mail, then don't allow mail-in ballots. Yeah, another good idea, Sheila. We should have our election completed on Election Day. What's Up Knox says, I still have no clue as to why old diaper De Niro frosted the mouth over Trump's, though. He is too old and incontinent to have been at a white party, isn't he? I don't know. You know, Elon was making that same point, talking about why did the billionaires, some of them all of a sudden hate Trump so much, right? Right as Reid Hoffman and Bill Gates and these other guys so anti-Trump. He speculated with Tucker that it was because Trump will release the Epstein list. And so I'm wondering, I think Epstein was the lightning rod for one sector, one demographic, mostly the finance bros and the academic bros and the political bros, right? Like the tech valley, Silicon Valley bros. He was the honeypot for them. Diddy was the honeypot for another industry, another domain, which is Hollywood and the arts. So I could easily see De Niro getting caught up in it. Kat Saunders. What's up, Kat Saunders? Bringing in Merwolf. Merwolf in the house, courtesy of Kat Saunders. Kat's a membo, bringing in new membos. Great to have you. Will Crump says, Judge says, you say our ruling would favor Democrats? Prove it. Reminds me of cunning criminal who stays one step ahead of the cops and then taunts them. Yeah, and then they set standards that are basically impossible to meet in the courts. Well, you have to show us that all of those undated ballots favor Democrats to show that there's a due process problem or something. Well, we can't show you that evidence, obviously, because that has not happened yet. You're going to allow it to happen. We're trying to stop you. But they know that. They're just being sneaky. Sheila Poo says the U.S. Postal Service endorsed Kamala. Is that right? Did they do that? The people who are handling our ballots have endorsed Kamala? Figures. Flea Speech over on Rumble says, like Fox's Jimmy Failla said, if Trump's MSG rally makes him Hitler, then Clinton's earlier MSG event makes Hillary Eva Braun. Laughing, laughing, laughing. Thanks, Bobby G and fellow watcher. Love from Denmark. What's up, Flea Speech? Thanks for watching on Rumble, and thanks for tuning in over from Rumble. Nice dono. Yeah, and this morning on our Membo stream, we played the clip from MSNBC saying it was a Nazi rally. Again, it's just wild how upset they are lately. Liberum says, I voted for Trump, still concerned about fraud. Rightfully so. Yeah, rightfully so. I think they're cheating openly by trying to manipulate the rules to count ballots that shouldn't be counted. There's a lot of that happening right now. We're covering it every day. Hey, Chief Vince. Thank you, Chief Vince. Chief Vince is a membo, bringing in 5 membos. Mike, vet fan, what's up? Debbie McDonald, Allison Lawler, Kevin Kessler, and Grant K. Gifted membos, courtesy of Chief Vince. Thank you, Chief Vince. We've got Tony Hay Munkets bringing in more membos. James Payton, welcome. Raz, welcome on board. Poem, Stephanie Roussel, howdy y'all. Patriot, Michael J, Sonny Spoon, Christian Harris, Gary Smith, gifted membos, courtesy of Tony Hay Munkets in the house. Thank you, Tony Hay. Michelle Perkins, welcome to 5 new membos. David Carter, C Fox, Donald Piedmont, Rico Johns, and Hippie, gifted membos, courtesy of Michelle Perkins. Thank you, Michelle P, in the house. We got Woodchip Bill, says, here's a scenario that should be looked at. What will Raskin do if Trump wins the electoral vote and the popular vote? Well, I think that clip that we talked about with him objecting to Trump was based on the 14th Amendment and other provisions and had nothing to do with the vote. Like if Trump wins, he's saying we're going to object. Tony Hay Munkets. Hey, it's the Munkets. Thank you, Tony Hay. Check it out. We got 10 membos coming in. Cassie's here. Raider Mac, CMW. We've got Freak Tractor, B-Cass, Annie L, Brewing, Barb Wood, Bad Weather Biker, and Supernova X, gifted membos, courtesy of Tony Hay Munkets. Hey, it's the Munkets. The answer is out there and looking for you, and will find you if you want it to. X-Files theme. Thank you, Ollie. Here's one from Tina. Welcome, Tina. We'll see you on the members-only stream this morning. This one is pronounced Sev Russ. It's pronounced Sev Russ. Baby's about to pop. Heck yeah, Sev Russ. Oh my goodness. So that one's going to be a tough one for me to remember. Sometimes I can remember these, but yours is not even spelled at all like it sounds. What is that? Sev Russ. Saihbreas. Pronounced Sev Russ. What's up, Sev Russ? I'll definitely remember that. Probably. Baby about to pop. Thanks for being a membo for 7 months. 2 more to go. And it's here. What's up, F. Joe Biden? Welcome. Is Jack Smith even a lawyer internationally or United States lawyer? What is he really? I'm sure he's a barred attorney at somewhere. I'm sure he's in there. I mean, I'm sure he was licensed here at some point because he did work on other Justice Department cases, but just not as a U.S. attorney. So I'm sure he's a lawyer, but just not appropriately appointed in this case. And yeah, great comment from F. Joe Biden. Hey, this one came in from Education and Career. Thank you, Donut. All right, so he went to Harvard. That figures. Harvard Law School, JD, 94. Joined the office of the U.S. Attorney. Where he worked there. Then he worked at The Hague. Then returned to the United States, also working at the DOJ. Then served as an assistant U.S. attorney, then acting U.S. attorney, and then head of litigation back for the hospitals. And then he went back to the International Criminal Court as a specialist prosecutor, and then he was over there for a while. So that's all. Yeah, that's a good background there. So, but he was not appointed as a U.S. attorney and not appointed in this case lawfully for this position. So, but he is a U.S. attorney, or he is a licensed attorney, not a U.S. attorney. Worked as an acting U.S. attorney and assistant U.S. attorney, but never appointed and confirmed as a U.S. attorney. Good summary there. Thank you for that, Donut. Thanks for clipping that, Johnny on the spot. White Buffalo says Vancouver Wash is across the river from Portland, Oregon. Good details. Thanks for filling in the gaps there, White Buffalo, and thanks for being a membo for 6 months. One old guy's opinion says Fuego in the heart of Sorat, in the heart of Antifa land, from one old guy. Hey, wild things forever, says the following. Says, hi, Rob. Just wanted to respond to a comment you made this morning about what is a Trump affect and how he is opening eyes to the corruption of the government's justice system and the attacks on free speech. The Trump effect, yeah. My hope is that our country, Canada, would see what's happening here, and finally this year it seems to be happening. Eyes are opening. We need a Trump win to be able to see the results and how much better it can truly be. Thanks, Rob, for what you do. Thank you, Wild Things. Yeah, this morning we were talking with our friends from the UK and obviously our friends from Canada. And our friends from the UK were saying, man, we hope you guys pull through this time because what's happening in Canada is crazy, or UK is crazy. Tommy Robinson, I guess, is back in jail for releasing a video. I mean, wild things are happening. And the idea is that a rising tide lifts all boats. Once people in America recognize, oh, you know what? Free speech is pretty good thing. Safe borders, pretty good. No wars, pretty good. Economy is pretty good. Kind of want to build things in your own country and so on. That's all good. And maybe other people in other parts of the world will latch on to that and things will improve, not only here in America, but elsewhere. So great comment. All right, we got that one. Hey, Elvis of Dallas. What's up, Elvis of Dallas? Thank you, Elvis, bringing in 5 membos. Kings fan, welcome. Rohan, you're in here. Hallie P, Alicia Heaton, and Kat Mega, gifted membos, courtesy of Elvis of Dallas. We had this one from Gloria B, just became a supporter. Welcome aboard, Gloria B. Grab the morning stream. We have one old guys says, why are Dems? I don't know. We got Finn says, Careless Whisper is a perfect song for Walz. If you know what the song is about. I don't know the song or what it's about, but Careless Whisper is even the name alone is a good name for Walz because he just makes stuff up. It's kind of like he whispers carelessly. He's just kind of saying whatever he wants. I carried weapons of war in war. No, you didn't. I was there at Tiananmen Square protest. No, you weren't. We used IVF. No, you didn't. I'm a command sergeant major. No, you're not. Stop whispering so carelessly, Tim. F. Joe Biden says, so it's true. Tim Walz likes Wang. It's too easy, isn't it? Sergeant GPS says, Rob, were you able to wear your Trump shirt to vote? No, I did not wear this into the into the location. I had a different shirt on. I was wearing a gym shirt. But yeah, I am wearing it now and I like it. Hey, what's up? Pang1 is in the house. Pang1 is here. Bringing in Tron, David Woodsmancy. We got Tectonic Edge, Trevor Smith, and Drew D in the house, courtesy of Pang1. Thank you, Pang1, for the 5 membos coming in. Stan Cottrell says, I was beaten and defeated while trying to fix the brakes on my 1989 van. You cheered me up. Thanks. Go Trump. Man, it would defeat me too. Obviously, you're probably a much more capable fighter in that arena. But do you know why we fall, Stan? So that we can stand back up. That's wisdom from the Bruce Wayne family. We've got this one. Knox Bierman says, Harris Co., Texas hiring poll workers for election day. Get your money for protecting the ballots. Here's a good PSA from Knox Bierman. Check that out. Get money for protecting ballots over at harrisvotes.com. But it's Harris County, not Kamala. Ollie, what's up, Kamala? Sorry, Ollie. What's up, Ollie? Bringing in Tom Fitton is hot. Hey, shout out to Tom Fitton. That dude has giant biceps. What's up? Have a great day, Libby. Thank you, Libby, for bringing in 5 membos. Libby, you're amazing. Matthew M is here. Heartbreaker, welcome. Otto Hoax. Reed Lambert is here. And Robert Lane, gifted membos, courtesy of Libby T. Thank you, Libby. Have a great day, from Libby. Hey, here's one from Floyd. You do realize that you rock. Much love. No Cuomo. Well, Floyd, that's one of the nicest things everyone said to me. And I appreciate you saying no Cuomo, because we don't want any Cuomo in this relationship. All right, that guy's something else. You do realize you rock back, Floyd. Thanks for the nice comment, my friend. I really appreciate you being here, and thanks for being a membo. No Cuomo at all. And no Don Lemon either. No. Knox, what's up? Says, we went over the USPS endorsement for Kamala, Robert. You may be absorbing too much info about this. We did? Was it a while ago? When was it? I mean, if it was, it wasn't recent. USPS endorses Kamala. Yeah, okay, so like September. Yeah, July 23rd, APW National Executive. So here's what I'm seeing. When the hell did that happen? I'm like, all right. Yeah, Harris, October 1st, NALC Postal Union. That was October 1st. Then this one, September 12th, NALC endorses Harris. Then July 23rd. Yeah, Knox, you're right. Once it's like a week old, it's pretty much gone because it's packed with all the new stuff. It's all gone. So, I mean, it's there. It's just loose. We have to make room for all the new garbage that's in there. But that sounds about right. Anyways, thank you for that, Knox. Hey, what's up? Norman Lee Smith Music says, winners don't cheat and cheaters don't win. Yeah, that's right. And cheating is just cheating yourself, right? Didn't your mother teach you that? Democrats, Jenna Griswold. Cheating is cheating yourself. Then people think you're a cheater. And you lose, ultimately, in the end. Knox says, you forgot a whole segment you did. Oh, that's nothing. A whole segment? I basically forgot what we talked about this morning, Knox. That's just how it is. Thanks for being here. I did. I forgot a whole segment. Hey, here's one from F. Joe Biden says, by the way, Robert, I did know about today Republican across the board. Like you did vote today, maybe, from F. Joe Biden. Amazing. Here's one from One Old Guy's Opinions. Says, you mean he bumbled many cases in the U.S. as a very bad attorney? Poor Jack Smith. YouTube will not allow certain words to be posted, like the Soros-funded Antifa. Got it. From One Old Guy's Opinions. Thank you for that. Floyd is here. Says, only the stupid Arsenal Union of the Postal Service endorse Kamala. We carriers, the majority, endorse Trump. There we go. Okay, so we have a little more clarity on that. So I don't know what the difference is. I just looked that up. So the NTEU, APWU. Looks like there's a lot of unions out there. What's up, Floyd? Thanks for the dono again. Hey, Tasadaka and Muffin Rando said, glad to know our carriers do work hard. Shout out to our postal service carriers. Tasadaka says, my aunts and their husbands are diehard Democrats. They voted for Trump. They're in their 70s and their 80s. Well, shout out to your aunts and their husbands. Welcome aboard. Glad to have them. We got ELZ says, myself and a couple friends had a micro rally on the side of the road in Deep Blue, Connecticut. Got hundreds of honks and even random people stopping by to take pictures holding our flags, including a couple of young ladies with tickets to the Trump rally at MSG on Sunday. Lots of support for Trump in the Nutmeg State. Look at this, baby. Yeah, fellas. Looking good. And I think that's a madam over there too. Sorry about that. It's kind of a grainy photo. But you look fabulous. Everybody looks amazing out there. So here is a nice photo. Trump Vance. Man, looking good. Amazing. Good to see you guys. Thanks for sending that one in. And Jack Mack, 14 months as a membo, says, nice Trump tee, Rob. Thank you, Jack. I like this one. It's got the nice flag over here. Very simple. Grab yours. Links in the description below. And you can buy them on YouTube through the YouTube store once I figure out how to do that. But my friends, thank you for those great comments, those great chats, those very nice, generous super chats. You guys are amazing, and I appreciate you. Let's see who's joining us on X on the day before we wrap it up and head on over to Locals for our members only after party. Let's see who's here. We've got Fred Pedamonte. His net worth, they say, is $20 million. Man, it's good to prosecute Trump. Wait until these cases are over and he writes a book about it. What's up, James Pepper? What's up, B-Torn? What's going on, Mario? We got Defense Strader. Shake says, if only expired coupons could be accepted when the expired date was smudged. Right. Can't get 25 cents off a hamburger, but you can certainly vote with a smudgy, non-existent postmarked coupon. Good stuff. What's up, Maynard? And Tracy. It's good to see everybody over on the X platform. Very nice to have our friends over there. If you're on X, you can follow your other friends on X, meet people in the wild, and of course, follow us over there at Rob Govea ESQ on the X platform. But my friends, okay, that is where we're going to leave it on the day. It's going to be a busy week. I can feel it in my bones. We've got from tomorrow 1 week until the election is upon us. And so if you haven't already, hopefully you're getting those ballots in and call in everybody you know to have them do the same because it's crunch time, baby. We're excited to get into it. So we'll leave it there. Before we wrap it up, I want to thank our mods and our meme smiths. Big thanks to Donut clipping for us all day today, man. Grateful for Donut. I saw Donut is in the chat. We got Playing Hookies in the chat. I saw K-Bean this morning. And hey, what's up, Just Rhonda? I did get your email from Just Rhonda. It's a beautiful day. Okay, so my friends, we'll leave it there. Thanks again so much for joining us on this lovely Monday. We are going to pause for the evening. We are coming back tomorrow, and we're going to get into it again. And in order to do that, we're going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.